In this subunit, we're going to discuss the UCC approach to the admission of extrinsic evidence. All right, let's refresh our memory about what we've learned in previous subunits about parole evidence. So we have parole evidence, which is just a prior or contemporaneous agreement. We have a written agreement, but we have some sort of prior or contemporaneous oral agreement or written agreement that didn't make it into the written agreement. Is that parole evidence admissible to the jury? And we said that if the parole evidence explains an ambiguous term in the written contract, then we would apply the plain meaning rule, and the evidence would be admissible depending on whether the written contract was actually ambiguous and needed an explanation. If, on the other hand, the parole evidence contradicts the written agreement, we'll apply the parole evidence rule, and the parole evidence rule will exclude the parole evidence. In other words, the jury will not see the parole evidence that contradicts the express terms of the written agreement. Finally, if the parole evidence adds to the written agreement, it doesn't contradict it, it doesn't explain it, the parole evidence adds to the written agreement, we might let the jury see it. Depending on what? Depending on whether the written agreement is a full or partial integration with respect to that prior agreement that adds to the written agreement. How is the UCC different? Well, the UCC is not different. The UCC is going to deal with the same thing. So the UCC rule deals with parole evidence that either explains, contradicts, or adds to the written agreement. So what is different? Why should we have a separate subunit on? Well, there's some slight differences. Number one, the UCC has a slightly different integration test. Remember, we're going to ask whether the written agreement is a full or partial integration with respect to that parole evidence. If the written agreement is a full integration with respect to the parole evidence, we're not going to let the jury see that parole evidence. If the written agreement is a partial integration with respect to the parole evidence, we're going to let the jury see that parole evidence. What was our integration test under the common law? It was the natural inclusion test or the natural omission test. The UCC test is very similar, it's just slightly different, so we'll just spend a little time on it. The next difference in the UCC is that it has a special and separate rule for evidence of course of performance, course of dealing, and trade usage. And we'll go into that in a little bit more detail. Let's take a look at UCC 2-202 and see how it is consistent with our common law parole evidence rule. All right, there is UCC 2-202. Now remember, in our common law parole evidence rule, we are looking for a written document by the parties, a written agreement by the parties. There we go. We have a writing that's intended to be a final expression of the parties. Now, final expression here does not mean full integration. It means partial integration. If it was a full integration, it would say a final and exclusive or final and complete. So this writing that is a final expression does not necessarily mean a full integration. But look what it says. It says, may not be contradicted by evidence of any prior agreement or of a contemporaneous oral agreement. Right? That is consistent with our common law parole evidence rule. Remember, our common law parole evidence rule said if we have a written agreement by the parties, it cannot be contradicted by any prior or contemporaneous agreement. All right. So the next question we need to ask is, well, what if we have an additional term, right? We have a prior or contemporaneous agreement that does not contradict the written agreement, but it supplements, it adds to. All right, well, there it says you can explain or supplement with consistent additional terms. So if your prior contemporaneous agreement is additional and it's not contradictory, it's consistent additional terms, then you can supplement the written agreement. But What if it is a full integration? Remember, we said under the common law parole evidence rule that if the parties considered their written agreement to be the final and exclusive statement of their agreement, if they intended it to be a full integration, then additional terms, evidence of prior or contemporaneous agreements that add to the written agreement, are not admissible. There it is. Now you see, if the written agreement, the writing intended by the parties, is a final expression, you can supplement it with additional terms unless the writing is complete and exclusive. This is consistent with our common law parole evidence rule. So, under the UCC, just like under the common law, we have to determine whether the written agreement is a full integration or a partial integration. Now, you remember our test under the common law, we would ask, is the parole agreement one that we would naturally and normally expect the parties to include in the written agreement? If we answer yes, the written agreement is a full integration, and the parties, and the jury will not see the evidence of the parole agreement. If the parole agreement is not one that we would naturally normally expect the parties to include in the written agreement, then the written agreement is a partial integration with respect to that parole evidence, and we will allow the jury to see the evidence of the parole agreement. So what's the test under the UCC? Well, it's just slightly different. Look at it. And this is comment 3 of UCC 2-202. If the additional terms are such that, if agreed upon, they would certainly have been included in the written agreement, in the document, then the evidence of their alleged making must be kept from the trier of fact. So instead of a natural inclusion test under the UCC, we're going to use a certain inclusion test. Let's compare the natural inclusion test and the certain inclusion test to see if there's any real difference between them. All right, let's just look and see how the different integration tests might operate differently. So under the common law, we said we use the natural inclusion test. If the terms of the prior contemporaneous agreement are such that reasonable parties in the same situation would have naturally and normally included them in the written agreement is fully integrated. And we understand that if the written agreement is fully integrated, then we will not admit any type of prior or contemporaneous agreement, whether it contradicts or adds to. The UCC seems to indicate that you should use the certain inclusion test. If the additional terms are such that if agreed upon, they would certainly have been included in the document, then evidence of their alleged making must be kept from the trier of fact. So they would have naturally and normally included them in the written agreement. It's not admissible. And they would have certainly included them in the written agreement. It's not admissible. Here, there might be a slight difference in how these should be applied. I think there are more types of agreements that would have naturally and normally been included in the written agreement. I think there are fewer types of prior or contemporaneous agreements that would have certainly been included in the written agreement. And therefore, theoretically, the certain inclusion test under the UCC would admit more evidence. It would admit more prior or contemporaneous agreements, at least theoretically. I don't know that a judge could actually make a distinction between the two in practice. But theoretically, the certain inclusion test should admit more prior or contemporaneous agreements than the natural inclusion test. In our introduction to this subunit, we said that the UCC has a special rule with respect to evidence of course of performance, course of dealing, and trade usage. So before we get into the special rule, let's review what course of performance, course of dealing, and trade usage are. So course of performance is evidence of the party's conduct under this contract. So we have a contract and one party wants to say, listen, my interpretation of this contract term is consistent with what we've been doing under this contract up till now. Course of dealing is parties' conduct, evidence of the parties' conduct in past but similar contracts. So one party says, here we have this written agreement, and my interpretation of this written agreement is consistent with what we've been doing under past contracts between us. Finally, trade usage. Trade usage is the custom in the industry, the custom or the practice in the industry. So once again, we have a written contract, and one party says, my interpretation of this written contract is consistent with what we do in our trade. You can see how this is all extrinsic evidence. It's all evidence outside of the written contract. Now, some of these we might consider to be parole evidence, right? A prior agreement. So course of dealing or trade usage we might consider to be a prior agreement. Why? Because what we've done under past contracts or what we've done in the trade is prior to our written agreement. So you can consider it parole evidence. Course of performance, I don't see how that is prior agreement because we enter into a contract and then we perform it. So what happens is not an understanding prior to our agreement, it's an understanding after it. In either case, it doesn't matter whether course of performance, course of dealing, or trade usage is parole evidence or not under the UCC because there is a separate rule for it. Let's look at that rule. Let's return to UCC 2-202 and see how it applies to the admission of evidence of course of dealing, usage of trade, or course of performance. All right, it's right there in 2-202 sub A. It deals with course of dealing, usage of trade, or course of performance. Now the question is, when will that be admissible when we have a written agreement? And the answer is, it can't contradict, but it can explain or supplement. So if we have a written agreement and we want to admit evidence of course of dealing, usage of trade, or course of performance, it is admissible to explain or supplement the written agreement, but not to contradict the written agreement. And you might ask yourself, well, what about a full integration? Well, the answer is it doesn't matter. For course of dealing, usage of trade, or course of performance, you don't ask whether the writing was a full or partial integration. Course of dealing, usage of trade, or course of performance is always coming in to explain or supplement the written agreement and not to contradict it, whether the written agreement is full or partial integration. And here's the evidence. This is where the UCC talks about a full integration in 2-202 sub B. And course of dealing, usage of trade, or course of performance is dealt with in UCC 2-202 sub A.